Topic for today's Ballard Spahr webinar is the ABCs of drafting enforceable severance, separation, and settlement agreements. We welcome your questions during and after the program, although we are limited in terms of timing. So please feel free to submit questions via the Q&A box or to email them to us directly after the program. If time allows, I will answer questions during the webinar. If not, I will follow up with you after the program. We have circulated the slides in advance, and we will also be sending slides along with a recording of the webinar as a follow-up to each of you. In terms of overview, the topics that we are generally going to cover today are general legal issues, recent developments at the EEOC, the specific requirements of the Older Workers Benefit Protection Act, or OWBPA, tax issues in settling employment claims, and finally drafting the agreement, A to Z +2, some practical topics and suggestions on how to draft your agreements. Let's begin with this thought. Whenever I speak, and for those of you who have heard me speak before, you know I always begin by saying that there's a very important question that the audience should ask every speaker at every continuing education program. And that important question from the audience to the speaker is this: why should I pay attention to you? What about this program is important? Why do I take time out of my busy day? There are two key takeaways for this program on this topic. I'll give you one now, and I will give you one at the end so that you'll have to stay and pay attention. The first key point is this: do not simply pull off the last settlement agreement out of your computer system, run it through the word processor, find and replace, change the names, and send it on. Drafting settlement and separation agreements is not simply a wordsmithing task. It is something that is important. We tell our clients, as lawyers and business people, they need to annually review and revise their employee handbooks. The standard form settlement separation agreement should be no different. It's very important that on a periodic basis you go back over the agreement and make sure that it's up to date. So what you need to do at the end of this program is to carefully reread your form agreement, because as you will see, each provision in that agreement is uniquely important. And what you need to do is challenge yourself, just as you challenge the speaker as to why this is important. As you go through the agreement, think about why every provision is in there, because that will help you have a better understanding of what is really important and what really needs to be included in these agreements. So there's your first takeaway. The first takeaway is to question your own agreement. So let's start going over the whys. In legal issues, first, why settle? Settlements are favored. How that settlements are a good thing? Because the Supreme Court tells us so. In Carson versus American Brands, the Supreme Court emphasized that Congress has expressed a strong preference for encouraging voluntary settlement of employment discrimination claims, and more generally, the general policy of favoring settlements of class actions disputes is even more forcefully applicable in Title VII cases because of the Congress preference for the settlement of such cases. Given that general policy, what can be waived? With federal law claims generally can be waived. That includes Title VII, ADA, ERISA, warrant claims, Section 1981 employment discrimination claims, and retaliation and whistleblower claims. State law claims are generally waivable, although that is a matter of state law, but most states apply the same breadth of favor towards the waiver of claims as the feds do. Unknown claims are waivable. Case called Bickings versus Bethlehem Lukens Plate from the Eastern District of Pennsylvania in 2000. A somewhat familiar scenario. On June 3rd, a RIF program is announced that includes a severance agreement. On June 4, the plaintiff applies for another job within the company as part of the RIF program. On July 11, the application for another job is denied. On July 22, the plaintiff signs the release, and then he sues not over his layoff, but on failure to hire him for another position within the company. The company arguing, the plaintiff says, that the release covered the layoff only, and the court said no. A release that bars unknown claims will be enforced even if a party claims that it was unaware of the matter at the time that the release was executed. Special cases, USERRA, the Uniform Services Employment and Reemployment Rights Act. This is an odd statute because it contains two provisions. Section 4302A provides that USERRA will not supersede or nullify an agreement that is more beneficial to the employee than the rights provided by the statute. But then Section 4302B provides that USERRA will supersede an agreement that reduces limits or eliminates any rights under the statute. Because of that, there was a recent split in the lower courts, but the clear trend is exemplified by a case called Wysocki v. IBM, a 2011 case out of the Sixth Circuit. There, the plaintiff returned from military service, demanded additional training. It became apparent that the employer and the employee were no longer getting along. They negotiated a separation agreement containing a broad release that contained no specific reference to USERRA. The Sixth Circuit affirmed a district court decision that enforced a general release that was part of the separation agreement negotiated after his return. The court held that USERRA rights could be waived as part of a voluntary release, provided the consideration was provided. However, the court made clear that its decision and the waiver of USERRA rights applies only to USERRA rights that have already matured. In other words, no waiver of future claims. Practice pointer here, simply specifically refer to USERRA in your agreement. MLA. Previously had been a split in the circuits regarding whether FMLA rights were waivable or if they were non-waivable along the lines of the Fair Labor Standards Act. Although the issue had been in dispute, recent revisions to the USDOL regulations specifically provides that under the FMLA, employees cannot waive, nor may employers induce employees to waive their prospective rights under the FMLA. By adding the word prospective, the regulations now make clear that rights that have already matured under the FMLA may be waived. Any allegations based on past employer conduct may be waived. Cannot be waived. Few claims, as we've talked about, cannot be waived. The Supreme Court in Alexander versus Gardner-Denver in 1974 stated, "We think it clear that there can be no prospective waiver of an employee's rights under Title VII." My favorite case dealing with the issue of prospective waivers involves the former basketball coach at the University of Arkansas, Nolan Richardson. He won an NCAA national championship in 1996 with a brand of play that he labeled 40 minutes of hell. Well, this case involved 40 months of litigation. Richardson was fired after publicly stating, after a difficult loss at Kentucky, quote, "If they go ahead and pay me my money, they can take my job tomorrow." Administration took him up on that and pressured him to retire. When he refused, Richardson was fired. His contract with the Arkansas Athletic Foundation, interestingly not with the university, contained a provision for a multi-year annual payout of $500,000 annually and a waiver of all potential claims, which was signed at the time the agreement was made. Richard sued for age discrimination. The university defended by claiming that Richardson had waived all claims with the signing of his original employment agreement. The Circuit easily found that the waiver was waived because it sought to waive his prospective rights that discharged several years after signing the agreement was ineffective to waive his discharge claims, and his acceptance of payments under the contract did not constitute a reaffirmation of the original agreement, and therefore not a renewed waiver. Practice pointer on this, the contract should have been written to provide that post-termination receipt of any payouts would be conditioned upon a release to be signed at that future time before the check is cut. Courts have also talked about the importance of technical compliance with OWBPA with respect to this future claims issue as well. In a case called Larkins in April of 2013 out of the federal court in Ohio, the release did not bar ADEA claims based upon new matter which arose after the release was signed. FLSA claims, Fair Labor Standard Act claims, are controversial. Historically, and going back 70 years, claims under the FLSA have always been deemed non-waivable without either court or U.S. Department of Labor approval and involvement. However, several courts have recently re-examined this position. In a recent case out of the Fifth Circuit, 2012, Martin versus Spring Break Productions, a labor union settled grievances regarding the amount of hours worked by union members. The settlement of the grievances stated that it was being settled on the union's own behalf and on behalf of the employees, with a full payout of all wages owed. The employees then sued, seeking liquidated damages under the FLSA, but the court rejected the argument that the claims had not been waived, finding that there had been a bona fide dispute, that there had been representation of the employees at the time, and that there had not been any compromise of the guaranteed substantive rights under the FLSA since the plaintiffs received a 100% remedy. So the private settlement reached in that case, albeit under somewhat unique circumstances, was held to be binding. In a case out of the Southern District of New York called Picerni versus Bilingual Preschool, a February 2013 case, there is a long and thoughtful and detailed analysis regarding whether a private settlement reached by the parties after litigation had begun, but without court intervention or approval, was still enforceable, and the court allowed the parties to voluntarily dismiss their FLSA action with a specific court hearing or intervention or approval of the settlement. Conversely, the 11th Circuit in July of 2013, in a case called Knoll versus Mal Motels, reiterated the oft-cited principle that FLSA settlements must be supervised by a court or the Department of Labor. Practice point here, in the settlement agreement, consider including a provision which is a representation of fact, not a waiver of legal rights, but a representation of fact by the employee that he or she has been paid for all hours worked appropriately. False Claims Act, key TAM actions. Clearly on the face of the False Claims Act, address the abilities of relators, defendants in the United States to enter into settlements following the filing of a key TAM action. However, the statute specifically says that a key TAM action may be dismissed only if the court and the Attorney General give written consent to the dismissal and their reasons for consenting. The FSA, the False Claims Act, is silent on the enforceability of a pre-filing release. And two cases out of the Ninth Circuit, Green versus Northrop Corp and Hall v. Teledyne, address this issue. And basically the principle of law to be gleaned from them is that so long as the United States has been given notice of the potential key TAM claim, the parties can then, filing of the complaint, resolve their complaint by way of an enforceable settlement. So the issue becomes knowledge of the government. One other practice pointer here. Once again, think about including a factual representation in the agreement that says the employee represents that he or she is not aware of any factual basis for a claim that the employer has defrauded the United States government and that the employee has not filed a False Claims Act cause of action. One other thing, and we'll talk about this more later, in this whole area of False Claims Act claims in the Sarbanes-Oxley world, think about including a provision in the agreement that also states that nothing in the release prevents the employee from filing a report with appropriate governmental authorities. Workers' comp claims cannot be waived as a matter of law in almost every state. As a matter of state law, consider factual representation where the agreement states that the employee acknowledges that he or she has incurred no work-related injuries. Unemployment compensation, once again, in every state, that is a non-waivable claim. However, there is a new development regarding unemployment insurance. The Unemployment Insurance Integrity Act of 2007 was intended to address unemployment insurance overpayments to ineligible individuals. Effective October of 2013, all states were required to have laws in place that required employers or their third-party agents to respond in a timely and adequate fashion to any state agency request for information, and more importantly, if the employer or third-party agency shows a pattern of non-responsiveness, the employers are punished. They can be charged even if the employee is ineligible for benefits, and there are other remedies on a state-by-state basis. So what constitutes a pattern of non-responsiveness? It varies state by state. In my state of New Jersey, it is 3. In Louisiana, for example, and in other states, it is 1. Now, what's the point of this for this discussion? A separation agreement that states that the employer will not contest the employee's application for unemployment insurance benefits runs the risk of being deemed non-responsive by state departments of labor. So those provisions, in my estimation, should be removed. For anyone practicing on a nationwide basis, as I do, would like a state-by-state chart on this issue, please send us an email and we can provide that to you. The right to waive claims through collective bargaining. And long established that unions may not waive an employee's individual right to file discrimination or age discrimination claims through collective bargaining. However, the Martin versus Spring Break case again shows a little bit of loosening of that, indicating that the union in that case could enter into an enforceable settlement with the employer resolving FLSA claims. And it is also clear that as part of grievance and arbitration proceeding, courts have routinely upheld the individual union member's right to waive discrimination claims without union involvement as part of that process. I think the practice pointer here is if you are in a union setting and you are entering into a global settlement of union grievances and discrimination claims, have the individual grievant sign the grievance settlement in his personal capacity and have the union sign on behalf of itself and the grievant. With respect to the right to file a charge of discrimination with the EEOC, we'll deal with that in a minute. With respect to the right to file unfair labor practice charges with the National Labor Relations Board, a Bush Board decision called BP Amico in 2007 upheld waivers signed by employees in exchange for enhanced severance benefits that waive their right to file unfair labor practice charges. However, given the clear trend of NLRB decisions in the area of arbitration agreements, I think it is clear that once the issue is presented to the Obama board, they will conclude that an employee cannot waive an individual right to file unfair labor practice charges. OSHA is to the same effect. An individual's right to file OSHA charges cannot be waived. Lastly, special requirements under state law. In California, unless an employee specifically waives the protections provided by Section 1542 of the California Civil Code, a general release will not be effective to waive employment claims. Therefore, releases in California must include an express waiver of rights setting forth the language of that section of the statute verbatim. Now, under more legal issues, when is a waiver enforceable? Now we're talking about the non-OWBPA context. Number one, there must be consideration. That is something of value beyond what the individual is already entitled. It can be paltry, it can be a pittance, it can be a bargain, but as long as it is something more than nothing more, the consideration prong is met. Non-involuntary is also required. Most courts apply a totality of the circumstances test, looking beyond the language of the release to consider all relevant factors, although a minority of federal courts apply ordinary contract principles, focusing only on the clarity of language in the release. In applying the test, the totality of circumstances test, courts look to 7 factors generally: the plaintiff's education and business experience, number 1; 2, the amount of time before signing; 3, the role of the plaintiff in deciding the terms of the agreement, in other words, were they negotiated; number 4, the clarity of the language; number 5, whether the plaintiff was represented by counsel; number 6, whether the employer encouraged or discouraged the employee from consulting with an attorney; and 7, whether the plaintiff had a fair opportunity to consult with counsel. Practice pointer: build a record that clients knew the terms and conditions of any settlement prior to signing. An attorney can bind the client to a settlement agreement. This is a matter of state law. However, a couple of interesting cases. Recently, a Fifth Circuit case, Casada versus Napolitano. There, at a court-ordered mediation, an offer to settle was made by the plaintiff's lawyer. It was held open for a period of time for the employer to accept. Drafts were exchanged. The employer accepted, and then the plaintiff claimed that her attorney did not properly inform her of the details. The court rejected that challenge, said that even though the agreement was never signed, the attorney of record is presumed to have authority to compromise and settle the litigation of his or her client. Practice pointer on this: make sure that your adversary, if you are an attorney, defines the scope of his or her authority, and additionally be sure to make clear your own authority as a lawyer vis-a-vis your own client in dealings with your adversary. Oral agreements may be enforced. This is a very important concept because, for example, a Seventh Circuit case, agreements settling bias claims are enforceable where there is a meeting of minds on all material terms, even though later there subsequently may be disagreement over additional terms while the parties attempt to reduce the agreement to writing. Number 2, like my favorite Star Trek movie, The Wrath of Khan, where Ricardo Montalban said, "I strike at thee from beyond the grave" to Captain Kirk, in a case called Lewis out of the Seventh Circuit, an oral settlement agreement of an FMLA claim was valid, even though after the settlement but before the agreement was reduced to writing, one of the defendants committed suicide. So even death cannot stop a settlement agreement. One odd exception, in a case called EEOC versus Phillips Services Corp., a 2011 Fifth Circuit case, a lawsuit brought by the EEOC to enforce an oral agreement reached during conciliation of a charge was dismissed because Title VII contains a provision barring the use of anything said or done in a conciliation session as evidence in a subsequent proceeding. So consider that a quirky case with good lawyering. Practice pointers. If you want the option to enforce a settlement, an oral agreement, do not suggest that the deal is tentative or pending the execution of a settlement agreement. Do not say that a proposed release is submitted for review or consideration. Instead, say something like, "Enclosed is the release, memorializing the agreement that we reached earlier today." If you want to foreclose an oral agreement, negotiate only in writing and make that clear as a ground rule. And be careful with last-minute requests for revisions. Be clear that you are discussing only possible modifications to an existing agreement. Now, for those dealing in my fair home state of New Jersey, of a August 2013 New Jersey Supreme Court case, Willingboro Mall Limited. This was a commercial dispute. After a successful mediation, the parties sued each other over the terms. Both of them waived a statutory mediation privilege and argued that agreement was reached on the one hand and not on the other. The Supreme Court was offended at this and issued a ruling that said if an agreement is reached at mediation, the terms of that settlement must be reduced to writing and signed by the parties before the mediation comes to a close, because mediation settlement should not preclude and should not be a prelude to a new round of litigation over its terms. So, number 1 practice point, either bring the agreement with you on your laptop and type it up right then and there and do not let people leave the table until it has been agreed upon and signed, or have the mediator agree to retain jurisdiction and hold the mediation open for a short period of time to allow the written agreement to be executed. When is not an enforceable waiver? These are the factors. First, duress. Duress generally manifests itself in an unfair, whether there is a fair opportunity to consider. 5 minutes is not enough. A New Jersey Appellate Division case, Carey versus NMC Global, in August of 2013. 24 hours is not enough. 30 minutes is not enough. However, 15 days is enough. About duress, this will vary depending upon state law, but in some states it is itself a crime to threaten someone else with prosecution for a crime. Therefore, be careful about using as leverage to get a release the promise not to file criminal charges. In Evans versus Waldorf Astoria Corp., a very interesting case out of the Eastern District of New York. There, the court rejected plaintiff's claim that her own attorney exerted undue influence in order to force her to sign the agreement. The court held that duress can only be applied by the opposing party. Fraudulent inducement. In order to prevail on this theory, the employee must show that the employer affirmatively misrepresented a material element followed by detrimental reliance by the employee. This most often manifests itself in the classic situation where the employer goes to the employee, says, "We are eliminating your position," lays them off, hands them a separation agreement, and after it's signed, immediately begins to advertise for the individual's replacement. That would be an indication of fraudulent inducement. Mistake is a basis to void a waiver, but it may be voided only if there is mutual mistake. If there is unilateral mistake, absent fraud or other inequitable conduct, the agreement is still enforceable. Lack of consideration we've talked about. However, keep in mind one thing. Payment for benefits to which the employee is already entitled is not adequate consideration. So if there is a severance pay plan and the employee is getting whatever the plan provides, asking for release based upon that policy will be inadequate. So therefore, practice pointer, review your existing severance policy and consider making it a bi-level policy that employees get some minimal amount of separation pay for no release, but enhanced separation benefits if they provide a clear release. Now, there have recently been some developments at the EEOC dealing with the issue of settlements. Most importantly, in the EEOC Strategic Enforcement Plan for 2013 to 16, they targeted 6 national priorities, one of which was to preserve access to the legal system. The EEOC wrote that it will target policies and practices that discourage or prohibit individuals from exercising their rights or which impede in the EEOC investigation or enforcement efforts. The policies or practices include overly broad waivers, settlement provisions that prohibit filing charges with the EEOC, or providing information to assist in the investigation or prosecution of claims of unlawful discrimination. Now, this is a reaffirmation of the EEOC's traditional position. The EEOC has always believed that the right to file any charge of discrimination is unwaivable. And last year, the EEOC obtained a consent decree in Northern District of Illinois in a case called EEOC versus Baker and Taylor because the employer was routinely conditioning receipt of severance pay on an overly broad severance agreement. So be aware of the EEOC paying more attention to this. Note that the EEOC has also always taken the position that the attempt to obtain a waiver standing alone constitutes a separate and distinct violation of the statute. However, that said, and remember also that the settlement with an individual does not terminate EEOC jurisdiction to investigate a potential violation or prosecute a charge. However, the EEOC has taken the position that where an individual executes a valid waiver or settlement and files a subsequent charge on the claim, the employer may be shielded from further recovery by the charging party, provided that the settlement agreement specifically states that the individual will not accept compensation or remedies as a result of the EEOC pursuing a case on his or her behalf. Now, asking for a release retaliation. The EEOC has taken the position in certain cases, and some courts have adopted the position that that's simply requesting a release that is legally inadequate from the EEOC's position is an independent action for retaliation. Most courts have taken the position that that's not the case, and that the offending provision of a settlement agreement may be severable. Now, with respect to the EEOC's duty to conciliate, obviously the step preliminary to reaching any settlement, we have seen a lot of litigation recently as to whether the EEOC has undertaken a good faith effort to conciliate charges before filing suit. Title 7 on its face states that the EEOC must undergo conciliation, and now we've seen a lot of litigation as to whether the EEOC adequately fulfilled the statutory requirement prior to filing suit. Most circuit courts are beginning to apply a three-step test. Number one, did the EEOC outline to the employer the reasonable cause for its belief that a violation has occurred? Two, did they offer the employer an opportunity for voluntary compliance? And three, did the EEOC respond in a reasonable and flexible manner to reasonable attitudes by the employer? There is a split in the circuit, though. Of three circuits, the 4th, the 6th, and the 10th apply a more deferential standard, looking only to see whether the EEOC has attempted conciliation. What we are seeing in the litigation is the EEOC investigating class claims, but not identifying individuals who have been allegedly damaged. And they're trying to use litigation discovery to build their class. This approach has been routinely viewed with disfavor by the courts. The 8th Circuit in EEOC versus CRST Van Expedited in particular excoriated the EEOC for attempting to use the post-complaint discovery process to conduct their investigation. And we've seen other courts go the same way. EEOC versus Bloomberg in the Southern District of New York in September of last year, a particularly telling case where the EEOC in a class matter sent Bloomberg a demand for settlement. Bloomberg said, well, we'd like to talk about this, and one day after receiving Bloomberg's response, EEOC declaring conciliation and filing suit. The court found that EEOC had completely abdicated its role in the administrative process, and that the appropriate remedy was the dismissal of the complaint. Now let's turn to the Older Workers Benefit Protection Act, OWBPA. Two key takeaways right at the start on the Older Workers Benefit Protection Act. Number one, the Supreme Court has made it clear that OWBPA says it on its face. Unless the statutory requirements are followed, a release of ADEA claims is not knowing and voluntary. And employees cannot waive their statutory rights to recover for age discrimination without strict statutory compliance with OWBPA. The other two key takeaways is that employers frequently get trapped by the complicated mass layoff or group termination rules. What are six? In order to comply with OWBPA, an ADEA agreement must be written in a manner calculated to be understood by the employee, must spell out the ADEA by name, must be in exchange for adequate consideration, must advise the employee in writing to consult with an attorney before executing the agreement. Here it is insufficient to say, I've had enough time to consult, or I've been recommended to consult. This must be active language, that the employer is advising the employee to seek counsel. They must have the consideration period, 21 days in the context of an individual termination, 45 days in a group termination, and there must be the 7-day revocation period. Note one thing that's important. In the context of a waiver of settlement of a charge filed with the EEOC or a lawsuit filed in court, The 21-day consideration period and the 7-day revocation period do not apply. In this litigation context, only a reasonable period of time will be adequate. Note, however, that this rule does not apply to pre-litigation mediations. Also, the agreement must not contain a tender-back provision which is triggered based on challenges to the validity of an ADEA waiver. In other words, the agreement cannot say that if the employee files suit to challenge the validity of the agreement, he or she must pay back all consideration offered. Practice pointer there, where there are both ADEA and other non-ADEA claims, a tender-back requirement is still proper with respect to non-ADEA claims. However, then the agreement must identify specific consideration for ADEA claims and for non-ADEA claims. Now, group terminations. A group termination consists of more than one. It's two. Two is a group. The employer must notify the affected employee and provide specific and burdensome information related to the group termination program. This information must be given in writing in a manner calculated to be understood by an average individual and at the commencement of the 45-day consideration period. What must be disclosed? The applicable decisional unit. Just go back for 1 minute into the 45-day consideration period and to show how narrowly these requirements are drafted. In a case called Fortunato v. Nestle Waters, there was a typographical error in the agreement. We referenced 21 days in one area and 45 days in another, and that release was invalidated because of that typographical error. Decision unit must be defined. The EEOC regulations say that portion of the employer's organizational structure from which the employer chose persons who would be offered consideration. There are two cases that show the extremes to which this rule can apply. In a case called Griffin versus Kraft Foods, the 5 Kraft plants produced the same product. The company considered all 5, selected one for closure, and provided information for the decisional unit at that one plant. When the AARP, you have a formidable plaintiff when it's the AARP, brought suit, the 11th Circuit concluded that the appropriate decisional unit was all 5 plants that had been considered. Therefore, because information was not provided for all 5 plants, the release was invalidated. The opposite situation was Pagliolo versus Guidance Corporation. There it was a nationwide RIF. The company said we considered all employees, all facilities, and provided 9,000 job titles by way of information. There the court said that was too much information. So Suflas' 7th rule for the practice of labor and employment law, when in doubt, the employer loses. The format for the disclosure is important. It must be job titles, both in the category of those who offered and those who were not offered. To show how narrow this can be, in a case called Peterson versus Seagate, at the time of the RIF, the employer provided information to 154 affected employees. Later, the employer admitted that the number of affected employees was really 152. That error of 2 people was enough to invalidate the entire release. 2 other notes. Note that a failure to comply with OWBPA requirements does not create an independent cause of action. And note also that courts do not use OWBPA requirements generally as a standard by which to measure the validity of claims in a non-ADEA setting. Tax issues. Number one, I'm not going to talk about executive comp, but be aware that there are extraordinarily complicated rules under Section 409A and Section 280G of the Internal Revenue Code governing separation payments to senior, highly compensated executives. If you are in that situation, find a good executive comp lawyer and work closely with them. In terms of tax issues generally, remember that this is an issue that plaintiffs and plaintiffs' lawyers always get wrong. It is abundantly clear that front pay and back pay damages are always taxable as wages, and employers making such payments must withhold income and employment taxes. Injuries, physical injuries, and damages attributable to physical injuries are not taxable. However, that is what I call hard damages. That is not pain and suffering. That is not compensatory damages. If the employee has medical, psychiatric, or psychological treatment, that will be non-taxable. But beyond that, all other recoveries, punitive damages, liquidated damages, compensatory damages are all taxable. And there is a reporting requirement. Now, that said, it is frequent that we turn a blind eye to the request of a plaintiff's attorney that the payment is made in lump sum, but practice pointer there, if you are going to do that, make sure that there is a broad and clear indemnification agreement running from the individual back to the employer. The issue of attorney's fees was hotly litigated for a number of years, but about 10 years ago that issue was solved with the passage of the American Jobs Creation Act of 2004. I note parenthetically that the late Daniel Schor referred to that piece of legislation as the No Lobbyist Left Behind law. The plaintiff and employer bar were effective lobbyists in that regard because attorney's fees are not taxable to the individual. However, they must be reported as income by the plaintiff. However, they are then deductible as a business expense outside the scope of the alternative minimum tax, and then taxes on the fee is paid by the lawyer. So, let's now turn to my checklist of practical and legal considerations to take into account in drafting the agreement. This summarizes much of what we already know, but let's run through it anyway. Number one, be clear that all claims are waived. So that general waivers are effective, but to be specific and to be in a better and more defensible situation, you should recite each every statutory claim encompassed by the release. Try to avoid mutual releases. In the Sarbanes-Oxley world, there are now cases where the employer is given a release to a senior executive, later found him to be guilty of significant mismanagement and financial problems, and to be in a situation where the employer cannot recover against the individual. Number two, B, dismiss all complaints and withdraw all charges with prejudice. Those are the magic words, and it is malpractice for lawyers not to include the with prejudice language. Also, include a requirement that the employee will execute any other documents or take any additional actions necessary in order to effectuate the settlement and dismiss or withdraw any pending legal proceedings. Covenant not to sue. In a non-ADEA OWBPA context, covenants not to sue are enforceable. However, remember, under the OWBPA, make expressly clear that the employee retains the right to challenge in court the validity of the settlement agreement. Practice pointer, consider adding language specifying that the employee is prohibited from suing on a released claim without first obtaining a final determination in court that the release is invalid. Consideration, we've talked about value, something of value beyond which to which they are already entitled. Practice pointer, nuts and bolts. State when the payment will be made, whether taxes will be withheld, to whom the checks will be made out, where checks will be made. One important practice pointer. Be sure that any differences in consideration offered to employees are coverable or explainable. There has recently been litigation brought by groups of plaintiffs who believe that they were victims of gender discrimination or race discrimination because the consideration offered to them by way of a separation agreement was less than that offered to white men. Confidentiality provisions are important. Establish at the outset of negotiations that a confidentiality provision will be required. It puts the employee on notice of the provision early and potentially inhibits him or her from unduly discussing the negotiations. What should they provide? That the individual has not disclosed and will not disclose the facts or terms of the agreement or the scope of the discussion. Make the employee responsible for breaches of confidentiality, although be careful about overly aggressive liquidated damages claims for breaches of confidentiality. We know that the settlement agreement will not bar disclosure under all circumstances. If the employee is requested to disclose by way of subpoena or other legal process, can include in the agreement a provision that states that the employee must notify the employer and agreeing that the employer has standing to step into any proceeding to contest disclosure of the agreement. However, as I said, the parties cannot create an absolute privilege or shield against civil discovery by written agreement. Note that in the FLSA context, some courts have stated that confidentiality provisions are unenforceable. NLRB and the EEOC are also now beginning to more routinely take the position that confidentiality provisions are unenforceable and indeed are violations of the statute as to those agencies. Practice pointers: avoid committing the employer to mutuality. A practice pointer for law firms: take care not to advertise the facts or terms of a settlement win for your client in a publication in which your law firm announces to the world this representation as an unqualified success. In a case involving a large California law firm, the inclusion of a confidentiality provision meant that when the law firm on its website touted its victory for the client, its reward was a lawsuit by the client for breach of the agreement seeking return of all legal fees paid. That's not a good thing for lawyers. Specific OWBPA language: remember to dot the I's, cross the T's. Advise to consult with an attorney in a manner that the employee understands, acknowledging the consideration is adequate, providing 21 or 45 days, and providing 7 days to revoke. Specifically, make sure that the states that the agreement shall become effective or enforceable until after the revocation period is expired. And lawyers, do not let your clients pay out the settlement proceeds before the 7-day revocation period has expired. I've seen that happen. To OWBPA or not to OWBPA, that is the question. Consider whether to ask for OWBPA language in a situation where you might get the revocation. Sometimes practical considerations indicate they may want to do that. More importantly, it is not an ADEA case. If you are not seeking an ADEA waiver, you should not include OWBPA language. A case called Neely versus Good Samaritan Hospital out of the Ninth Circuit. There was settlement agreement in a race discrimination claim. However, the plaintiff was over 40, OWBPA language was included, and she exercised her 7-day right to revoke. And the Ninth Circuit said it did not matter that no claims had been made for age discrimination. Once the employer asked for the waiver, the revocation right automatically followed. Non-disparagement clauses vary in the Obama NLRB world. They now believe that non-disparagement clauses inhibit the Section 7 rights of employees. Note that that theory does not apply to supervisors or senior managers, but take that into account in drafting non-disparagement clauses. Practice pointer: avoid mutual non-disparagement. In my estimation, employers have too many people to specifically commit to non-disparagement. I think it's unmanageable. As a fallback position, if the plaintiff really insists on it, agree that only certain identified persons will commit to non-disparagement. Non-admissions clause: no admission of wrongdoing by the employer. This is a must, and no agreement should fail to include a non-admissions clause. non-assistance, non-cooperation clauses. In the past, I routinely included them. Now, not always. The EEOC considers such clauses to be invalid, as does the NLRB. More importantly, in light of the passage of Sarbanes-Oxley, I think employers should be careful not to draft any language that would appear to interfere with an employee's ability to speak to the Securities and Exchange Commission, the U.S. Attorney, the FBI, or any other legitimate law enforcement agencies. The Dodd-Frank Act bars companies from taking any action to impede an individual from communicating directly with the SEC staff about possible securities law violations. Interestingly, a group of plaintiffs' law firms recently wrote to the SEC calling for the agency to take a firm stance against language in settlement agreements, which would indicate non-cooperation or non-contact with the EC. Specifically deal with the issue of attorney's fees. Remember that a settlement involving a payment of consideration to a plaintiff or an employee renders that person in litigation a prevailing party, which automatically triggers the statutory right to attorney's fees. In a recent Seventh Circuit case last year, Sanchez versus Prudential Pizza, Judge Easterbrook of the Seventh Circuit wrote, quote, "Once more we must teach defendants that making Rule 68 offers of judgment to be specific and clear. Any ambiguities will be resolved against them. As a result, anything that does not deal with attorney's fees will trigger a right for the individual's attorney to move for fees as a prevailing party." Obviously, a disclaimer of any oral representations. Only the written agreement will govern the result. Right to recover fees in the case of breach. Remember again that under OWBPA, the validity of the agreement may be challenged without the harsh penalty of tender back. However, that does not apply in a non-OWBPA format, and tender back rules can apply there, as we've already discussed. No reemployment. Once they're gone, they stay gone. Argued that no reemployment provisions are unlawful attempts to waive future legal rights. However, therefore, the carefully worded agreement says that this is a covenant or promise not to apply or seek reemployment, rather than a waiver to file a lawsuit in the future or a waiver of right to apply for reemployment later. EEOC regulations support that view. Provide for the return of company property. For restrictive covenants, this is very important. A recent case out of the Northern District of Illinois where the agreement, there was a non-compete restrictive covenant which the employee had previously signed with the company. However, the separation agreement said this agreement supersedes all prior agreements. The court easily found that thereby invalidated the restrictive covenant. So if a restrictive covenant is already in place, reaffirm it as part of the separation agreement or deal with the issue specifically in the separation agreement. Severability and savings clauses should be routinely included, and that the waiver in this agreement is an essential part of the parties' agreement, and that if the waiver is not valid, the employer is relieved of its obligations. Tax indemnifications we've spoken about. Child support obligations. In some states, any settlement payments must be applied to past due child support payments. That is the case in New Jersey. Therefore, obtain a representation and warranty from the employee, the male employee or female, I guess, that no such child support payments are due. The Medicare, Medicaid, and SHIP Extension Act of 2007 requires that all entities that pay settlements or judgments to any personal injury plaintiff, that goes back to the issue of physical injury damages in a discrimination claim, who receives Medicare or Medicaid payment benefits must report that information to CMS. Indemnity and hold harmless clauses will not circumvent the government's right to recovery. Therefore, there should be an acknowledgement in the agreement that there is when Medicare has paid a portion of the plaintiff's medical bills, steps should be taken to avoid a Medicare lien. The agreement should be binding on others. Choice of laws provision should be clear. There should be a provision to address the resolution of breaches. However, note that EEOC regulations under OWBPA, again, reference the need for a court of competent jurisdiction to determine the enforceability of the agreement. Use plain language. Remember, this goes to the knowing prong. The language and reread it as if you are not a lawyer. Be sure to define all key terms using legal mumbo jumbo. Remember the OWBPA timing. However, material changes to the final offer restart the consideration period. However, a restart of the consideration period is waivable. Therefore, provide specifically in the agreement that any changes, whether material or immaterial, do not restart the consideration period as the agreement is revised. Note the 7-day revocation period cannot be shortened by the parties. In a lame duck situation, sometimes you have a separation agreement where people are staying on in exchange for a bonus. In that case, provide for a two-part waiver. One signed at the time that the overall separation agreement is signed, and then a requirement in order to receive the subsequent payment. A second waiver will be signed at that time. Again, the Coach Nolan Richardson situation. Deal with the issue of references. Usually we only provide severance data, census data. However, if the employer has knowledge and a good faith reason to believe that the employee has engaged in serious misconduct, such as sexual harassment or sexual assault, carefully consider whether even a neutral reference can be provided. How do you respond when you are asked the question by a future employer, is the plaintiff rehirable? If you listen to my earlier advice and the plaintiff has promised not to reapply, you can say, yes, they are rehirable, but they will not be reapplying in the future. This is important because in a case called Matthews versus Wisconsin Energy, improper statements made during the reference period that are inconsistent with what was provided for in the separation agreement can be grounds not only for invalidating the agreement, but also a separate cause of action for retaliation. What are legal ramifications of not settling after offering to settle? Most courts hold that offers to settle or offers of a release of claims are not admissible as evidence of settlement. However, there are a few aberrational decisions out there that where no claim or dispute has been asserted by the employee, asking for a release, not getting it, and then pulling the settlement agreement off the table is viewed as a separate act of discrimination. Last point. I always like to conclude with a topic which says, when the going gets tough, the tough get weird. For lawyers out there, do not settle a case that you have won. Sheng versus Starkey Labs. Employer goes to mediation. Counsel returns to his office after successfully settling the case, opens his mail, and in his mail is an order of the court granting his motion for summary judgment. So again, don't settle cases that you have already won. I promised you a final takeaway. It is in two parts. Suflas' fourth rule for the practice of labor and employment law is hogs get fed, pigs get slaughtered, and Suflas' first rule is in the immortal words of those great philosophers Mick Jagger and Keith Richards, you can't always get what you want, but if you try sometime, you just might find you get what you need. In negotiating and drafting your settlement agreements, don't be a pig, be a hog. Remember to get what you need. Don't just ask what you want. Focus on what is really important and end it that way. Thank you very much for joining us today. Again, feel free to reach out to us with any questions. Contact information is available on the slides. As you exit the program, you will see a short survey on your screen. We would appreciate your taking a moment to complete the survey. Your feedback is very helpful to us in planning future programs. Thank you very much for your attention.